Jay, if I can find it.
Good evening.
Yeah, really. So, item number 5.
Thank you, Madam Chair and Senators. AB 1675 is a bill that will ensure that children who are being sexually exploited and get caught up in that are put into programs to address that issue. They are victims. We should not be treating them as victims. And so we've created a process in this bill that would require probation to prescribe a specific program of supervision, sort of an informal probation, if you would, with the goal of getting the necessary services to those children in lieu of filing a petition to have them declared a ward of the juvenile court, the delinquency side. And if they are wards on the dependency side, to make sure that they are that the child welfare knows what's going on and that they can be addressed on the dependency side. Again, these are victims, these are children. They need to be treated as victims and not caught up and punished as criminals. That's not furthering the goals for California. And with that, I ask for an aye vote. I do have some witnesses here in support.
Thank you.
Thank you, Madam Chair and members. Alice Kessler, I'm here on behalf of Equality California. We're proud to sponsor the bill. I was also asked by the American Civil Liberties Union to voice their support. The reason why Equality California so vigorously supports this bill is that we do see LGBT youth disproportionately represented in the homeless population, the foster youth population, and juvenile justice settings. And that is because too often, they are rejected from their families and they face societal rejection that puts them in those situations. And very unfortunately, they oftentimes may need to turn to survival crimes or become the targets of child sexual exploitation. And we think that this is the right approach for those youth, that we're talking about minors who can't even consent to sex. They shouldn't be prosecuted as criminals. We need to get them linked in with services, and we need to ensure that we can get them on a better path forward. So we would ask the committee to support the bill today.
Thank you. Are there other speakers in support of the bill? Are there speakers in opposition to the bill? You don't have to leave. There's room at the table. Yeah.
We're actually listed in support and opposition, so I wasn't sure when to jump up. Sean Hoffman with the California District Attorneys Association, unfortunately here today in opposition to the bill as it's currently drafted. We appreciate the author and his staff. We've had several conversations with them over the last couple of months dealing with the bill. We appreciate their intent. We would agree that the first time that one of these individuals is encountered, it's appropriate. Informal supervision works. It's important to connect them with those services. Our concern is with mandating that course of treatment in subsequent contacts with that individual if perhaps they have failed an informal supervision program and they're picked up subsequent to that. And we're not even saying that it shouldn't be available then. We just believe that it should be at the discretion of the probation officer, that they should be able to decide whether to institute informal supervision or refer the case to the district attorney's office. So as the bill is today, we are still in opposition, and I'm also here on behalf of San Diego County District Attorney Bonnie Dumanis.
Okay, thank you. So I wonder, Assembly Member, if you wanted to respond to those concerns.
I would. We started this journey actually working with the DA from San Diego County and the DA's Association, and I think the issue ultimately is that the DAs want to exert, probation wants to exert more jurisdiction if something, as he said, has been tried and failed. But in reality, it often takes going into services multiple times. And yes, that child is back on the street, but we need to be able to bring them in again, and sometimes again, in order to ultimately change that behavior, to get them motivated, that child motivated in the right direction, unlearn what they've been taught on the streets and by the folks who are ultimately running them. These are very sad and very, very difficult cases to deal with. But at any case, to not allow the time and the interactions to work with that child and solve the problem, to have that discretion to them drop them into juvenile hall or into the criminal system, I think we have a much higher possibility of losing them ultimately. And I think that's really what the discussion has been as we go back and forth with the DAs. And some of the DAs have very good programs, Alameda, for example, and we've been talking to the district attorney there who wants to keep the program within the DA's office. It may be working there to some extent, but we're trying to create a model for all of California, and we're actually trying to create then a demand and this notion that in every county, there needs to be a place for these children to go. In my own county in Santa Cruz, there isn't specifically a program, and yet when law enforcement does come across a child who's a victim of being sexually exploited, they will essentially do this. They will come up with a program, find a placement for that child, not pull them into the criminal justice system. This is the behavior that we want to encourage and ensure that all 58 counties are doing the same thing. And Madam Chair, as you and I have talked, it does beg the question of what services are available in all counties. They are not available in all counties, but there are solutions that are available depending on the willingness of that county to divert that child and find a path or a program. Unfortunately, it might mean moving a child out of the county, as recently happened in Santa Cruz, to an adjacent county for that child because there was, in fact, a program to send them to, but a much better outcome than holding them in the criminal justice system. So that's what we're ultimately trying to do. And we have been threading the opposition, and that's why we've been working with law enforcement and the advocates. This is a difficult issue. It's a hard one to solve for California, but working within the structures that we have, taking advantage of the counties that are doing well and pushing the other counties to create a program like this to make sure that they have a place for those children to go and come up with a creative path for them will ultimately serve those children much better.
Thank you. Are there other questions or comments from members of the committee?
Madam Chair, and I know we've had this discussion on this committee before about victimizing children that are engaged in sexual trafficking, and I certainly understand the initial arrest being given informal probation to try to get the child into some social service apparatus to help them get out of this horrific lifestyle. But to repeatedly see them recidivate and putting them back into these social programs that obviously are failing because the kids are still getting trafficked, to me is problematic. It's basically decriminalizing juvenile prostitution by mandating that there's only one penalty, and that penalty is informal probation. I think that there needs to be more consultation on a second episode, if you will, with the district attorney to understand the dynamics of what's going on and allow the district attorney to file the appropriate charges as necessary.
Yeah.
But again, if I can respond to that,
Sure.
the problem that I have with that is that's the underlying assumption that here's a child who is a criminal. This is a child who can't even legally agree to be having sex. I mean, we have laws around that. And if we hold that over their head and we prosecute them and we turn them into criminals, we have lost that child. Sometimes it often does take. I mean, in the child welfare system and in any instance where we're dealing with troubled children with trauma, they are going in and out of programs. Yes, it's heartbreaking, but to just at some point say, okay, we're done, you're a criminal, we'll treat you as a criminal, is to me just absolutely astonishing in how we deal with these children. And even well-intentioned, we have a place for them to go. We will bring them in the criminal justice system in order to protect them, but throwing them into juvenile hall isn't protecting them. Treating them as criminals, giving them a criminal record isn't protecting them. We have to protect these children, and we have to do it sometimes on their own terms and the way that they need to be worked with and respected in the process. And that's why we're trying to set up a process where there is some supervision and there is a program, there is a place for them to go, but they do run away. They do struggle with, you can offer them help, they don't always take it, and sometimes it takes a few times for them to wake up and take the services. But by just saying, once, twice, you're done, we're gonna treat you like a criminal, I think that really works against the fact that they're truly a victim and we're turning a victim into a criminal, and that's the problem that I have.
Yeah, really, thank you for that. I have to say, because you and I have talked about this just briefly, that I have a number of sort of mixed feelings about this too. Partly because it's almost like a juvenile mirroring of the LEAD program, which I believe in very, very strongly from Seattle, which does give discretion to the beat officer to really make the decision about whether a person is ready for services or is not. And also who knows how many places there are to take them at any given time. That requires also training of the beat officers. I don't know how we train probation officers now to recognize those nuances of when a person is ready. I'm also very concerned about counties that may have no services. I mean, I represent some counties that are fairly rich in services. And the thing that is kind of shocking to me is that we don't know because we've never asked. We don't really have an inventory of what's available for these young people, so that if, in fact, there are counties with no services, is it a matter that they just wanted to keep building jails with their CCP money? Or is it that they're broke and never had services? Are there things we can do? There's a lot that we need to find out. Having said that, I totally think you're on the right track. We're trying to get, these are children, and they probably have had almost certainly some very traumatic experiences in their lives. So we want to try to get them on the right track. I am wondering, the bill is moving forward to appropriations. And I'm very interested in how we could get data, whether the BSCC would be the people to do that, whether the Probation Officers Association could do that, so that we would actually have some lay of the land about what services are out there. And also what they had in Seattle with the LEAD program was an evaluation from the University of Seattle that showed they were saving a huge amount of money by doing the diversion and the services instead of the criminal justice system and the emergency room. I suspect the same thing would be true here, and we could save a lot of lives. But I am interested in the follow-up data and how we can get that. But maybe we could work on that or think about that.
And I'm actually very happy to do that, and that's one of the reasons this bill was set up the way it was, and why I brought up the Santa Cruz example, because that's a county that doesn't have specifically these services, but under this sort of a thought, they still found a way. They found what they needed to do for that child. And I think even though the DAs are opposed to this, they have actually been a pretty good partner in this conversation. We have a lot of agreement, and we have a lot of agreement on ultimately what we're trying to do. There are just some differences in how we get there in some of the details around it that we're working through. But there's really a broad coalition that are trying to solve this problem and come up with a way to ultimately make it work out. And I very much appreciate the conversations that we've been able to have. But yeah, getting that data, which counties are doing what and how that's going to work is very important. But what this bill requires is that it doesn't dictate a particular set of services, but just that there's a path. And I think counties, if we pass this and we make this as a requirement, we'll figure it out. And they're already getting monies through different avenues to be able to solve some of these problems. I think they can do it within what they're already getting under realignment and all of the other kind of components that come together to address the youth. This is a larger population than we would like it to be, but it's from what counties are dealing with in probation and delinquency and all that, it's a smaller part, especially in the smaller counties.
Right.
So it's very possible, it's very doable. What we're really asking is that the counties then find a path for these children.
That- oh, a motion would be just fine, Senator Leno. Okay, I'm sorry, but I do get very interested in this, so I did want to follow up even though Senator Stone.
Thank you again, Madam Chair. You know, I think we can all agree that it is a horrific crime when we see children involved in basically sexual trafficking and slavery. And every time you put a child through a prostitution event, it leaves almost an irreversible scar of trauma on that child that they will have to live with for the rest of their lives. It's much easier to intervene after one event than to condone that it's going to take 3 or 4 times into social services before the child finally sees the light. I don't comprehend why we don't put into statute a much more comprehensive intervention program, even if it's state-funded and augmented, which requires the detention of the child to be within the social services network for, say, 30 days, because what happens is that these children get diverted into social services, and what do? They run away. And they go back to their Johns that are showing them love, and they're very confused. And I don't think that we give our social services network the opportunity to intervene on these lives that are being destroyed before us and allowing them to be, these are children, to be put back into sexual slavery. I think it's revolting. It's revolting, and I wish we collectively could do more on the front end instead of pushing them back out into this horrific environment that is going to leave them scarred for the rest of their lives. So I wish there was an alternative that we could consider to this. I just can't see pushing the kids back in and saying, well, hopefully they'll see the light and we'll be able to fix them after irreversible damage is done.
And I was just reminded, DA O'Malley out of Alameda County has an institute that's running statewide and is actually working on that question about what services are available, where they are, and trying to do a much deeper dive into this issue.
Oh, great.
So
Thank you.
it looks like we are on a path to get that information sooner rather than later.
So, and I think this is the first step, and maybe we can get a program and get it funded. We'll learn from the data, and we'll learn from trying. If the bill passes, but it's a very,
Thank you.
very, very, very good first step at any rate. Thank you.
Thank you,
So,
Madam Chair.
the bill's been moved. Please read the roll. Oh, would you like to close?
That's all. Thank you.
It's been a long day.
It's been a long day. I have another 30-minute close if that's all right.
All right. Hancock?
Aye.
Hancock, aye. Anderson? No. Anderson, no. Glazer? Glazer, aye. Leno? Leno, aye. Lou? Lou, aye. Monning? Monning, aye. Stone? Stone, no.
That bill passes 5-2. Thank you
Thank you.
very much. And I'm going to lift the calls. Okay. Just to note, item 1 was pulled by the author. He may bring it back next week or next year or sometime. Item 2 by Calderon, AB 1241, audio video piracy. Chair voting aye, vice chair voting aye.
Glazer? Glazer, aye. Leno? Leno, aye. Lou? Lou, aye.
Okay. 7-0, that bill is out. Item 3, AB 1662 by Chow on drones. Chair voting aye, vice chair voting no.
Lou? Lou, aye. Monning? Monning, aye.
Okay, that bill passes 6-1. Item number 5, we just voted on. Item number 6, AB 1680 by Rodriguez. Again, on drones, chair voting aye, vice chair voting aye.
Glazer. Glazer, aye. Leno. Leno, aye. Lou. Lou, aye. Monning. Monning, aye.
Okay, 7-0, that bill is out. Item 7, AB 1708 by Gonzalez. It was, the motion is do pass as amended. She took a number of amendments. Chair voting aye, vice chair voting aye.
Leno. Leno, aye.
7-0, that bill is out. Item 11, AB 1798 by Cooper. Chair voting aye, vice chair voting aye.
Leno. Leno, aye. Lou. Lou, aye. Monning. Monning, aye.
7-0, that bill is out. Item 12, AB 1820 by Quirk. Chair voting aye.
Anderson. No. Anderson, no. Lou. Lou, aye. Monning. Monning, aye.
Okay, 5-2, that bill is out. Item 13, AB 1824 by Chang on service dogs. Do pass to appropriations. Chair and vice chair voting aye.
Glazer. Glazer, aye. Leno. Leno, aye. Lou. Lou, aye.
7-0, that bill is out. Okay. Item 15, 1869, AB 1869 by Melendez relating to firearm threat.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Glazer. Aye. Glazer, aye. Leno. Lou. Oh, wait, okay, hold on. Leno. Leno, aye. Lou. Lou, aye. Monning. Monning, aye.
Now that I voted, were there amendments?
No.
What?
Were there amendments on the amendment?
No. No one. I didn't remember it as being, okay. That bill is out. Item 17 by Irwin was put over. Item 18, AB 2012 by Bigelow, Jail Industry Authority, chair and vice chair voting aye.
Glazer. Glazer, aye. Lou. Lou, aye. Monning. Monning, aye.
7-0, that bill is out. Item 19, AB 2078 by Kim on protection orders, chair, vice chair voting aye.
Glazer. Glazer, aye. Lou. Lou, aye. Monning. Monning, aye.
7-0, that bill is out. Item 20 was pulled by the author. Item 21 on driving privileges by Linder, AB 2088.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Monning.
Okay, 6-0. That bill is out. Item 22, AB 2147 by Eggman, vehicle impoundment, chair voting aye.
Anderson. Aye. Anderson, aye. Glazer. Aye. Glazer, aye. Leno.
Question, please. Is there an amendment here?
No?
Okay, so this is asset forfeiture prior to any charge or conviction, correct? So I'm no.
Okay.
Leno, no.
Leno, no.
Lou. Lou, aye. Monning.
Not
5-1.
voting. Yeah, so that is 5-1.
Madam Chair, I'm sorry to trouble you. Can we go back to item 15 for just a moment, please?
Yes, we can. Oh,
I just wanted to clarify, as the notes say, this is virtually identical to AB 1176. It is. So, I'm sorry, with consent of the committee, could we take that vote again? Because I'd like to be a no vote on that, sorry.
okay. We would have to vote to rescind, right?
No, we can't rescind. You can do, because it passed, the motion can be a motion to,
Expunge?
no, we don't do expungement. Motion to reconsider. And then if the motion to reconsider passes, you can take the vote up again.
Okay.
I'm sorry for the trouble. I'm sorry for the trouble.
Okay, so is there a motion to reconsider? I'll make the motion. Thank you. And call the roll, I guess? Yeah.
The motion to reconsider.
Consider.
Hancock.
Aye.
Hancock, aye. Anderson. Aye. Anderson, aye. Glazer. Aye. Glazer, aye. Leno. Leno, aye. Lou. Lou, aye. Monning.
May we keep the roll open on this? Maybe perhaps we could call Senator Stone, because he voted on it before, he will have missed out.
Yes, on the motion to reconsider, how about on the main vote?
I'm saying keep it open on the main vote.
Okay, so let's finish the motion to reconsider.
Okay.
Did you call a vote?
Yes. Monning. Monning, aye. Stone, oh, sorry.
Okay, so the motion to reconsider passes.
Yes.
We'll skip over that for the moment.
Okay.
Do you want to announce something?
Do you want a motion on the bill again?
Not yet. We need to get Senator Stone back.
Maybe we could just move ahead with the rest of the agenda and come back to it.
Okay.
Thank you, Sergeant.
Okay.
So we'll go to item 23.
Right. The item 23, AB 2165 by Bonta, handgun roster exemption for police officers. Chair and vice chair voting aye.
Motion was due pass as amended to the floor. Lou? Lou, aye. Monning? AB 2165.
Item 23.
Monning, aye.
Okay, that bill passes 7-0. Item 24, AB 2199 by Campos.
Motion was due,
Chair, okay,
motion was due pass as amended to appropriations. Hancock?
aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye.
Okay, 7-0, that bill is out. The consent calendar,
No, not done.
what,
We're not,
I think, no,
We'll do the consent calendar.
no. Which one are we doing?
Consent calendar, did you call?
yeah,
Okay.
Consent calendar.
Okay. Glazer? Glazer, aye. Lou? Lou, aye. Monning? Monning, aye.
okay. Item 26, probation exemptions from handgun roster, as amended, and the Bonta bill would be as amended as well. Chair voting aye, vice chair voting aye.
Leno? Leno, aye. Lou? Lou, aye. Monning? Monning, aye.
Item 28, gang databases, AB 2298 by Weber.
Motion was due pass to appropriations. Hancock?
Aye.
Hancock, aye. Anderson?
No.
Anderson, no. Monning? Monning, aye.
Okay,
Senator
five
Stone's here.
5-2. Okay,
You want to go back to Melendez?
okay, back to item 15. Is there a motion on
Back on
item?
15.
Well, first of all, we're opening the roll for the motion to rescind or reconsider.
It already passed, Senator.
Oh, so we're just gonna, this is the motion now. Okay, thank you.
I'll make the motion for
Okay, for moving the bill? Okay,
So the motion was due pass to appropriations. Hancock?
aye.
Hancock, aye. Anderson?
Aye.
Anderson, aye. Glazer?
Changing my mind. No, aye.
Glazer, aye. Leno? Leno, no. Lou? Lou, aye. Monning? Monning, aye. Stone? Stone, aye.
Okay, 6-1. That bill is out. Item 29, AB 2320 by Calderon on drones. Chair voting aye, vice chair voting aye.
Glazer? Glazer, aye. Leno? Leno, aye. Lou? Lou, aye.
7-0, that bill is out. Item 30, AB 2361 by Santiago, private university law enforcement. Chair voting aye.
Anderson?
Aye.
Anderson, I. Leno? Leno, I. Lou? Lou, I.
7-0, that bill is out. Item 32, AB 2510 by Linder on, CCW licenses. What are those? Okay, oh, they're not CCPs? Okay, CCW licenses. Chair voting aye.
Anderson?
No, excuse me, no to aye. Aye.
Anderson, no to I. Leno?
This is item 32, AB 2510.
Oh, I thought okay, aye.
Leno, I.
Okay. 7-0, that bill is out. That is it. Thank you all, everyone. The
Did we have
meeting
consent? Did we do
is,
the consent?
We did the
yes,
consent.
Oh, you did?
yeah. And you-